Hello, friends, and welcome back to another episode of the Liberty Weekly podcast. I'm your host, as always, Patrick McFarlane, and this one is episode 133, and the show notes may be found at libertyweekly.net/133. And today I'm going to be talking about the lockdowns, and I'm sure that this is not, this is probably a topic that you've heard quite a bit about before, but hopefully not from the angle that I'm going to take here. And I wanted to highlight specifically, I alluded to in earlier podcasts, I think it was the one on Ruth Bader Ginsburg, which kind of signified my return to the Liberty Weekly podcast and podcasting in general. That one may be found at libertyweekly.net/130. But there is a Supreme Court justice on the Wisconsin Supreme Court who has written a very, very good number of dissents for the certain Supreme Court orders that have governed the judiciary in Wisconsin in the judicial system. And I think that it warrants review and warrants some of the light that I'm going to be giving to it on this show. And it's full of language and things that we have talked about before on the show, especially in the episode that I did on the Magna Carta. And I'm going to be trying to find that now because I think it's one that you all should go listen to. Magna Carta. Let's go and look at. Still trying to get used to I'm live streaming right now this episode on YouTube, and I'll be doing some live streams on solo episodes. So check that out at youtube.com/Liberty Weekly. But as you see on the screen here, the real Magna Carta is one of the episodes I did that I'm most proud of. And it's at libertyweekly.net/58. I'll be putting that in the show notes page. But as you can see, I really enjoyed doing for you watching the video version, I really enjoyed doing the thumbnail because there's a lot of, I do this thing where I take my logo and I put it over the heads of everyone if there's like a famous portrait. So it looks kind of funny. But the Magna Carta, as I talk about in that episode, and I talk about Lysander Spooner's episode on trial by jury, his essay rather on trial by jury, and that's at libertyweekly.net/56. But he really talks about how trial by jury, the right to trial by jury in due process, is something that goes back all the way to the Magna Carta. And the Magna Carta itself is actually a document that harkens back to an earlier time where the subjects of the monarchy or regular Englishmen were hearkening back to a period of time, the Anglo-Saxon times, and even later into the rights that they understood that all free Englishmen had. And the affront that has come to our liberties is unprecedented when it comes to the lockdown orders. And I don't think that this should be a statement or anything that's controversial. In Wisconsin, for instance, the Wisconsin Supreme Court just put down a new order in the last couple weeks that allowed the circuit court judges to renege on their plans to start jury trials again. And some of the circuit courts around the state have been they've been resuming jury trials. They've been trying to conduct the jury selection process in voir dire, doing it remotely. So some have rented out gymnasiums where they've brought a few hundred people in to do jury selection, and they have 2 or 3 courtrooms set up that are all linked by video monitors where the jury can view what's happening in the courtroom. And the lengths at which they're doing is just outrageous. But of course, even if you're a judge that doesn't believe in all this crap, doesn't believe in quite the dangerousness of COVID as it's been racked up to be, you have to follow along with the social distancing CDC guidelines. But at the same time, if you are a judge, I think that's worth anything, your concern should be with due process, and that should be one of your main concerns. And due process and the right to trial by jury is something that is more important than all of this, more important than safety. And as we'll be discussing here, Justice Justice Rebecca Bradley does a great job talking about that. And here on the screen, you can see the most recent order, and it's 47 pages long, and I'm not going to go through every single page of the 47 pages here, but you can see Justice Rebecca Bradley with some just great language. And I'm sure she's not great on everything, but so I would almost say mandatory viewing before you listen to this episode is my episode on the real Magna Carta and the episode on jury nullification, because I go through and talk about Lysander Spooner and his great piece. And I think, I linked to the full text, trial by jury, here, so you can see that on the screen. There's a lot of information talking about the history of the Magna Carta, and so that'll be linked in the show notes page here. And it's something that is so sacred in our legal system, in the Western legal system, in the common law system, that I don't believe there's ever been a time, and maybe it's just because of my ignorance, but I don't think there's ever been a time where there's been such an affront to such our fundamental liberties, and no one is concerned about it. No one is really, I don't know, it's just disappointing. No one's concerned about the fact that you might have people who are sitting in jail who have demanded a speedy trial, which is their constitutional right, and they're just sitting there rotting away. I mean, they have a right to bail. Sometimes they're not able to post it, but if you can't post bail, you can make a speedy trial demand. And it's just not happening because of this crisis. And I would posit that if you can have a public health crisis, if you can suspend such a fundamental liberty because of a public health crisis or a crisis, anything can be a crisis. Climate change is a crisis. You can gin up any kind of crisis, and that's how you get rid of liberty. So here's the October 1st order from the Supreme Court of Wisconsin. In re the matter, so that's not a typo, but initially there was an order called In re the matter of the extension of orders and interim rule concerning continuation of jury trials, suspension of statutory deadlines for non-criminal jury trials, and remote hearings during the COVID-19 pandemic. And civil jury trials are not happening. And I think this is an affront to due process, because people, when you're talking about some of the most fundamental things that make our civilization, and the fact that they're not happening and no one cares. Think about this. If you were injured horribly in an accident, well, I would call it a crash because I'm a personal injury plaintiff lawyer. Accident, the term accident actually kind of, it insinuates that it's no one's fault, when accidents usually are someone's fault. In rare case, they're not, but I digress. Let's say you were injured horribly in a crash, and it's been a couple of years, you've been on the mend, and you have hospital bills that you can't pay for, and you are paralyzed, you have future care needs that need to be taken care of, and you're going bankrupt because of this. There's healthcare providers that are after you, but you can't help it because you need to be taken care of because you're paralyzed, and you don't have family to rely on. I'm playing the smallest violin here, but let's say you're in that situation and you've been going through a litigation process for a few years trying to get compensation because someone drove drunk or what have you. Either they drove drunk and injured you and laid you up for life, or they had a deck that wasn't up to code, and I know libertarians are probably autistically screeching right now, but you can have requirements that aren't based on statute for the way that things should be built. You could have insurance companies that have certain standards for building decks. But let's say you're in that situation, you're up the creek without a paddle, and all of a sudden you're going through, you have a scheduling order with the court, you are meeting your expert deadlines, and you're doing discovery depositions, and all of a sudden the court decides that there's a COVID-19 pandemic and suspends your right to a civil jury trial. And now there's no hammer with which you can chase after the defense, because, ultimately it's the threat of a jury trial that they might lose, which is what forces them to settle. Maybe they know that they're screwed, but if they know that they can let you sit off, maybe they have, they're up against a wall too, and they have so many claims this year that they didn't have last year, and they don't want to pay out right now. Well, they can put you on the back burner, and you have no recourse to try and force them to settle with you because there's no threat of a civil jury trial. And of course, all the criminal jury trials take precedence. It takes preference. It's more preferential. They want to finish the criminal jury trials first. So you're just sitting there, your whole life is ruined. You can't settle your case because there's no threat of imminent doom behind the insurance company, and it's not fair is the point I'm trying to get at. And that is a fundamental right that a lot of people don't think about, because the criminal process, takes a front seat because it's your life and liberty at stake if you're wrongly accused, or if you're justly accused in the same way. So, taking a look at this, you are hereby notified that the court has issued the following order that amends the court's May 22nd, 2020 order of the same title. So on May 22nd, I don't know if that's when the original order that came out regarding the suspension of jury trials, I think it is, but I thought it all went down in March, so I'm not sure. But this is the legal foundation that they come up with. They've come up with to suspend your constitutional right to a jury trial. So whereas the COVID-19 pandemic continues to require certain mitigation procedures, including social distancing, blah, 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 meant to reduce the increase in person-to-person transmission of the virus that causes COVID-19, and whereas the Supreme Court has administrative and superintending authority over the courts and judicial system of this state, and a duty to promote the efficient and effective operation of the state's judicial system. This is pursuant to the Wisconsin Constitution, and one of the cases that they cite, which interprets the Wisconsin Constitution, that's In re Kading. It's a 1976 case. Whereas, and it is the Wisconsin Supreme Court the Wisconsin Constitution that has authority over this, but it is the federal Constitution that imposes the right of due process according to federal guidelines onto the states through the window of the 14th Amendment, which we talked about in one of the last episodes here. But whereas the Supreme Court has issued a number of orders intended to minimize in-person proceedings in the circuit courts of this state during the COVID-19 pandemic, including the March 22nd order as amended April 15th, in re the matter of remote hearings during the COVID-19 pandemic, which suspended until further order of this court most in-person hearings in the circuit courts of this state. That's the district courts, that's the county level courts. That's where it's the trial court level, the circuit court, for those of you who might not be familiar with it. The circuit courts of this state, subject to limited exceptions for certain matters, if remote technology is not practicable or adequate to address the matter. March 22nd, 2020 order, in re the matter of jury trials during the COVID-19 pandemic, which continued all criminal and civil jury trials scheduled to occur prior to May 22nd, 2020, to a date after May 22nd, 2020, to be scheduled by the circuit court judge presiding over the case. So on March 22nd, 2020, continued all criminal jury trials scheduled to occur before May 22nd. It rescheduled them to a date after May 22nd to be rescheduled by the circuit court judges presiding over the cases. On March 31st, 2020, Interim Rule 02 in the matter of an interim rule suspension of deadlines for non-criminal jury trials due to the COVID-19 pandemic. Isn't this just a mouthful? Which suspended statutory deadlines for conducting non-criminal jury trials until further order of the court. So you're talking about, I think this, I might be wrong on this, but this could apply to CHIPS cases, child in need of protection. That's not the exact acronym term, but it's about children who are in need of protection of the court. I'm wondering if this suspends this, or TPR cases, termination of parental rights. I'm wondering if this suspends those cases, which are really important if you're thinking about it. April 13th, 2020 order, in re the matter of filing of court documents in civil and appellate courts. It's a temporary mailbox rule which deemed documents to be filed as of the day they were mailed. There's a mailbox rule. It's this is an aside, but in the law you have this idea of a mailbox rule which says that certain documents such as contracts or something like that, or filing court documents are deemed to be filed or transmitted once you put it in the mailbox and have it stamped appropriately and addressed appropriately. It's deemed to be sent that day. Whereas the Chief Justice has convened a Wisconsin court's COVID-19 task force, the task force which has prepared a final report that makes recommendations to the circuit courts of this state for planning and preparing operational plans to resume in-person proceedings, including jury trials, which report and recommendations this court has adopted to provide information and recommendations for county circuit courts and other judicial stakeholders, and to provide them with a resource for making sound decisions in their community while safely transitioning back to full and in-person circuit court operations, including the resumption of in-person proceedings and trials. Now, this all sounds super, super nice and warm and fuzzy. Oh, we're going to keep everyone safe, and we're going to allow the courts to continue doing jury trials once they can reach our final report, which makes these recommendations, the COVID-19 task force. Well, the reality of this situation and how it's playing out in lots of circuit courts across the state that I've heard through the grapevine and in the courts and jurisdictions in which I practice, they just don't have the resources to stand up to these and meet the final report recommendations. I mean, there's only, let's say in a certain county in which I practice, it's a larger county and there's 5 courtrooms in the county. There's 5 branches. There's 5 different judges in the county. Well, only 2 of those courtrooms are equipped to handle these jury trials with the social distancing and all that's in place. And it's not practical. You can't have that. And so therefore this jurisdiction has suspended jury trials till next year at the earliest, because they just can't account for it. So to continue, whereas the task force has concluded that fundamental requirements for, another thought is that, some counties have 5 branches, 5 different judges, 5 different courtrooms. Well, some counties in the backwaters literally do not have the technological requirements. They are not funded well enough to actually meet these deadlines to do remote hearings. So in those counties, there's grant money that's coming, I'm sure, and they've been scrambling to set up for remote jury trials or remote hearings even. So whereas the task force has concluded that fundamental requirements for a gradual resumption of in-person proceedings are 1, the use of face coverings by all individuals present in the courtroom, the jury room, or other court-related confined spaces, and 2, the practice of appropriate sanitation, hygiene of frequently touched surfaces in the hands of participants, and whereas the public health emergency makes everything the Constitution go away, caused by COVID-19 is ongoing, which requires that the orders and interim rule identified above must be extended, but this court has determined that individual circuit courts of this state may begin gradually to resume in-person proceedings, including jury trials, on a county-by-county basis if the circuit court prepares a plan to do so safely That includes the requirements set forth below, and that plan is approved by the Chief Judge of the Circuit Court's Judicial Administrative District, which would result in the termination of certain orders, and the interim rule for that circuit court in all individual municipal courts may also begin to resume in-person proceedings as set forth below. That the court's May 22nd, 2020 order of the same title expressly stated the provisions of that order shall be subject to further modification or termination by future orders. So we're going to set this order for you to continue at your discretion to resume in-person proceedings as long as you do it according to our guidelines. Also, we can change those guidelines whenever we want. Shall be subject to further modification or termination by future orders. And whereas the conditions regarding... We're talking about people's lives here. Whereas the conditions regarding the COVID-19 public health emergency in existence on May 22nd have changed, and there is a need to amend the court's order to address those changed circumstances to allow the chief judges to withdraw approval of previously approved operational plans as described below. So here's a change coming that, like we just discussed. So, conditions have changed. We're going to allow our chief judges to go back and withdraw our approval of plans that we have already approved of. Therefore, it's hereby ordered, pursuant to this court's administrative and superintending authority, that the April 13th order in re the matter of filing of court documents, so the mailbox rule is extended. The remote hearing applies to each municipal courts, and until the chief judge for the judicial administrative district has issued an order approving an operational plan pursuant to footnote 3 below, so we won't get into that. But the order is extended for each circuit court until that circuit court shall have prepared an operational plan for safe resumption, and get that approval. Yep, okay. So when a circuit court's operational plan has been approved by the chief judge, the amended order shall cease to apply to that court, so that's when they can resume in-person proceedings and jury trial. So I'm not going to keep going with all of these. You can read the rest of it. But it describes all the hoops that you have to jump through. So one is a statement: the circuit court judge or judges have communicated with the clerk of the circuit court and with representatives of the county's sheriff's department, the DA's office, and the local office of the state PD, if applicable, regarding the safe resumption. So the judge has to talk to all the different departments. Everyone has to wear face coverings unless the judge has specifically determined on the record that the witness testifying, should not wear a face covering, because you can judge the credibility better that way. The plan also has to specify that notices regarding this requirement will be posted at the entrance of each courtroom, and the requirement will be enforced by the judges of the circuit court. They have to enforce it. The practices for appropriate sanitation, hygiene of frequently touched surfaces, and the hands of participants, so everyone has to use hand sanitizer, disinfecting wipes all over the place. And yep, you gotta keep these in place, and you have to have it approved by the chief judge. So there's a whole bunch more info here. So if you'll bear with me here. So let's see what some of the justices have to say in dissenting from this order. Due to the COVID-19, so Judge Annette Kingslander Ziegler dissents. The court's orders issued in the spring of this year were to address an emergent and temporary situation regarding the COVID-19 pandemic. Unfortunately, this amended order does nothing temporary, but instead breathes new life into the court's previous orders, which were to terminate upon approval of each county's individual plan. Those March and May court orders should have an end date rather than being resuscitated. See, so we're getting some pushback, and that's what this episode is about getting pushback, and some justices who are, while pushing back against this and trying to stick up for people, even though they're not perfect. We continue to manage the individual counties as if there was one solution for all. I would prefer to allow local control and have the counties reach sound decisions based upon their facts and circumstances. Thank you. Justice Brian Hagedorn joins the dissent. He is a newly elected, more conservative justice. Rebecca Grassel Bradley, who is the hero of this episode, although I'm sure there's decisions she's made in the past that are not friendly to libertarianism. However, I think you'll like what she has to say. So she says, on March 22nd, 2020, the court issued an order in re the matter of jury trials during the COVID-19 pandemic, which suspended all criminal and civil jury trials until after May 22nd, 2020. I dissented from that order because it violates the right to a speedy trial guaranteed by the U.S. Constitution and the Wisconsin Constitution. On March 31st, 2020, the court issued Interim Rule 2002 in the matter of an interim rule suspension of deadlines for non-criminal jury trials due to the COVID-19 pandemic, which indefinitely suspended statutory deadlines for conducting non-criminal jury trials. I dissented from that order because the court exceeded its authority by infringing the substantive rights of litigants to have their cases tried within the time frames established by the legislature. On April 15, 2020, the court issued an amended order in re the matter of remote hearings during the COVID-19 pandemic, which indefinitely suspended in-person proceedings in appellate and circuit courts. I dissented from that order because it did not provide an end date. It's just in limbo. The original order issued on March 22, 2020, suspended in-person court proceedings through April 30th, 2020 only. On May 22, 2020, the court issued an order in re the matter of the extension of orders and interim rule concerning continuation of jury trials, suspension of statutory deadlines for non-criminal jury trials, and remote hearings during the COVID-19 pandemic. I dissented from that order because it continues the indefinite suspension of criminal and civil jury trials with no consideration of the constitutional or statutory rights of litigants. Again, with no consideration of the constitutional or statutory rights of litigants. I would terminate these orders and leave the matter of conducting circuit court proceedings to the circuit court judges, who at this point have had 6 months to evaluate when and how they may safely conduct jury trials and other proceedings, in consultation with leaders and stakeholders in their respective counties, and with the benefit of additional recommendations and guidance from the May 15, 2020 final report of the statewide Wisconsin Courts COVID-19 Task Force, as well as their respective chief judges. With no consideration of the constitutional, and I'm adding it again, but with no consideration of the constitutional or statutory rights of litigants, everyone is just letting this happen. Well, I'm trying to speak up against it, I suppose. It's unprecedented. It's just outrageous. And with the benefit of additional recommendations of the task force, the court's latest order abandons the idea that circuit courts have the competency to implement operational plans for safely conducting proceedings, which they do, and it continues to indefinitely suspend criminal and civil jury trials in violation of the constitutional and statutory rights of litigants. For the reasons more fully expressed in my dissents prior orders of the court, I again dissent. And she's attached her dissents, which is the real meat of this here. So this is her initial dissent, which I thought was incredible. Just incredible. This is gonna be great. So this is against the March 22nd, 2020 order in re the matter of jury trials during the COVID-19 pandemic. The Wisconsin Supreme Court suspends the constitutional rights of Wisconsin citizens, citing the exigency of a public health emergency. The Constitution does not countenance such an infringement. Emergency, this is a quote, emergency does not create power. Emergency does not increase granted power or remove or diminish the restrictions imposed upon power granted or reserved. The Constitution was adopted in a period of grave emergency. Okay, well, we can debate about that. However, her point stands. I mean, the Articles of Confederation, I don't know if that created a good situation by our standards, perhaps. You could argue the other way. Um, so the Constitution was adopted in a period of grave emergency. Its grants of power to the federal government and its limitations of the power of the states were determined in the light of emergency, and they are not altered by emergency. This is a quote from Home Building and Loan Association for v. Blaisdell, was a Supreme Court case, 1934. Although I think that's from the Progressive Era Supreme Court. However, I digress. The Sixth Amendment to the U.S. Constitution commands, quote, in all criminal prosecutions, the accused shall enjoy the right to a speedy trial. It's the U.S. Constitution. Wisconsin's highest court says a public health emergency justifies a blanket 60-day suspension of a constitutional right. I think that's wrong, but that's what they said. If that is true, then the following constitutionally enumerated rights of the people, among others, are also subject to a suspension by judicial decree. The free exercise of religion, the freedom of speech, the freedom of the press, the right of the people to peaceably assemble, the right of the people to petition the government for a redress of grievances, the right of the people to keep and bear arms, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. Informed by these lessons of history, the Constitution was established to safeguard the rights of the people, even under the most exigent circumstances. The framers, quote, foresaw that troublous times would arise when rulers and people would become restive under restraint. Might be pronouncing that wrong, I apologize. And seek by sharp and decisive measures to accomplish ends deemed just and proper, and that the principles of constitutional liberty would be in peril unless established by irrepealable law. The history of the world had taught them that what was done in the past might be attempted in the future. The Constitution of the U.S. is a law for rulers and people equally in war and in peace, and covers with the shield of its protection all classes of men at all times and under all circumstances. No doctrine involving more pernicious consequences was ever invented by the wit of man than that any of its provisions can be suspended during any of the great exigencies of government. Such a doctrine leads directly to anarchy or despotism. Yay. But the theory of necessity on which it is based is false, for the government within the Constitution has all the powers granted to it which are necessary to preserve its existence, as has been happily proved by the result of the great effort to throw off its just authority, says Ex parte Milligan, 1866. And, interesting. So, going up a page, Wisconsin's highest court says a public health emergency justifies a blanket 60-day suspension of a constitutional right. I see. So she's saying that that's what the Wisconsin court just did with this order. I believe it was a 60-day order. So that's where that confusion came in. The Sixth Amendment's Speedy Trial Clause enshrines an ancient liberty. The Assize of Clarendon, an English code of legal procedure established in 1166, probably butchered that pronunciation, mandated speedy trials for the accused, quote, without delay. In 1215, following the English barons' revolt against tyrannical rule, the Magna Carta, libertyweekly.net/58, promised, quote, to no one will we sell, to no one deny or delay the right or justice. And she has a quote here. A citation. Looks like to a legal treatise. The right to a trial by jury is a, quote, valuable safeguard to liberty and the very palladium of free government. This is the Federalist, Alexander Hamilton, wrote that. The Speedy Trial Clause's core concern, and Alexander Hamilton was a huge statist. So, I mean, you have to take that he would be saying that as something that's powerful. Quote, the Speedy Trial Clause's core concern is impairment of liberty. Doggett v. United States, Justice Thomas dissenting. The public interest in a broad sense, as well as the constitutional guarantee, commands prompt disposition of criminal charges. Strunk v. United States, 1973. With respect to the rights guaranteed by the Sixth Amendment, so strong was the sense of the country of their importance, and so jealous were the people that these rights, highly prized, might be denied them by implication that when the original Constitution was proposed for adoption, it encountered severe opposition, and but for the belief that it would be so amended as to embrace them, it would never have been ratified. I think that quote is referring to the Bill of Rights. Ex parte Milligan, cited above. Quote, time has proven that the discernment of our ancestors for even these provisions, expressed in such plain English words that it would seem the ingenuity of man could not evade them, are now sought to be avoided. Nothing in the Constitution, that was a quote, that was all case law, the last few paragraphs. Now she continues with her argument. Nothing in the Constitution permits the judiciary to limit the fundamental rights secured under the Sixth Amendment. Quote, there is only one instance in the Constitution where the government is expressly permitted to suspend a fundamental right. Law Review article provides, the privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. If the framers had contemplated suspension of the Sixth Amendment rights or any other liberties, they would have said so in the text. So she's a textualist. The court's order not only overrides the U.S. Constitution, it flouts the Wisconsin Constitution, which mandates, quote, in all criminal prosecutions, the accused shall enjoy the right to a speedy public trial. Article 1, Section 7 of the Wisconsin Constitution. While utterly ignoring the supreme law of the land, the court expressly refuses to follow statutory law. The court says, quote, the ends of justice served by temporarily suspending jury trials in the courts of this state outweigh the interest of the public and the defendant in a speedy trial under Wisconsin Statute Section 971.103a. Under that statute, criminal trials in Wisconsin, quote, shall commence within specified periods of time, depending on the nature of the charges. Continuances are statutorily permissible, provided circuit court considers multiple case-specific factors. The broad sweep of the court's order precludes every circuit court in the state from exercising its discretionary power, which is what the circuit courts have, a lot of discretionary power. That's how everything works. To weigh various statutory factors, including the interests of the victim, before granting a continuance. The all-encompassing nature of the court's order, postponing every criminal jury trial in the state of Wisconsin for a minimum of 2 months, cannot comport with the Sixth Amendment speedy trial mandate. We let this happen, people. We let this happen. Which, although not strictly construed as to forbid any delay whatsoever, quote, necessarily compels courts to approach speedy trial cases on an ad hoc basis. We can do little more than identify some of the factors which courts should assess in determining whether a particular defendant has been deprived of his right. Though some might express them in different ways, we identify 4 factors: length of delay, the reason for the delay, the defendant's assertion of his right, and prejudice to the defendant. That's Barker v. Wingo, a Supreme Court case from 1972. The court's blanket order dispenses with both constitutional and statutory requirements to consider on a case-by-case basis the rights of the accused, the interest of victims, and the best interests of the public. Under Wisconsin law, every defendant not tried in accordance with this section shall be discharged from custody. Violations of the Constitution's Speedy Trial Clause require dismissal of the charges against the accused. Let's read that again. Violations of the Constitution's Speedy Trial Clause require dismissal of the charges against the accused. Quote, in light of the policies which underlie the right to a speedy trial, dismissal must remain, as Barker noted, the only possible remedy. And as an aside, for all of you watching on the live stream, I just realized that the title to this episode is still Voting the Opiate of the Masses. How about against the unconstitutional suspension of jury trials in Wisconsin? Yeah, that sounds like a great title. And we're going to try and change the thumbnail here too. Sorry about this. This is going to be fun to edit out in post. And for all you listening, thanks for bearing with me. Okay. That's a little bit better. I don't know if it'll change. Anyways, let's see here. History teaches that grave threats to liberty often come in times of urgency, when constitutional rights seem too extravagant to endure, when we allow fundamental freedoms to be sacrificed in the name of real or perceived exigency, we invariably come to regret it. Skinner v. Railway Labor Executives Association, 1989. Supreme Court case. Justifying the suspension of the people's constitutionally guaranteed rights based on a public health emergency nullifies our Constitution. Justice Antonin Scalia once explained that, quote, every tin pot dictator has a Bill of Rights which he casually ignores. What was debated in 1787 and what ensures our freedom is our structure of government, which holds each branch, and in turn by its people, to account. If the people's constitutional rights may be suspended by the judicial branch in the name of a public health emergency, our freedom is in peril, our republic is lost. Well, ding, 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 wake up. More than 1 million Americans have died defending our liberty from external threats. The liberty for which so many have laid down their lives should not be cast aside even in, quote, troublous times. If the government will not protect constitutional rights designed to preserve our freedom, it is up to the people to reclaim them. Is that an endorsement of the Boogaloo? By a sitting Supreme Court justice? Of a state Supreme Court justice, rather, but so here is another dissent in the matter. That was the end of the first dissent that she did to the initial lockdown order. I remember reading it at the time, and I was resolutely impressed. So she continues her dissent to Interim Rule 20-02. She attached as an addendum to her dissent here. She says, I think this is when the order was extended. Actually, I'm not sure. We'll find out. So the use of the court's superintending authority in the matter it is now being used can become addictive and lead to abuse. Over and over, our opinions repeat the mantra that our superintending authority is, quote, unlimited in extent or, quote, limited only by the necessities of justice, as though there were no bounds to the court's power to do, quote, justice. This sort of nonsense needs to be exposed before this court does something that will provoke a crisis. Oh, here is where it gets spicy. In a footnote she puts, citing no legal authority whatsoever, Chief Justice Roggensack's concurrence presents a textbook example of an ad hominem attack. Instead of a substantive response, this concurrence appeals to people's emotions and fears associated with COVID-19. Every action this court takes must be governed by the Constitution and other applicable law and not panic. As a former circuit court judge, I trust Wisconsin circuit court judges to adequately and appropriately address the concerns raised by the Chief Justice in her concurrence regarding the practical aspects of conducting jury trials amidst the threat of COVID-19. The law affords circuit courts the flexibility to do so as well as to adjourn them, but the law does not permit this court to indefinitely suspend the operation of law at the expense of substantive rights belonging to Wisconsin citizens. Whenever any branch of government claims the authority to act beyond the boundaries of its powers, the people should be alarmed. I write for the people who cherish liberty and who recognize that elected officials are their servants and not their masters. Although she does say, this concurrence misunderstands my dissent, which nowhere suggests that civil jury trials must go forward now. Any modifications to the time or place for jury trials must be made on a case-by-case basis by the circuit court judges presiding over them in accordance with the Constitution. This concurrence also betrays a fundamental misunderstanding about the scope of the majority's own order. Even though the order applies to civil trials only, the concurrence purports to speak on behalf of prosecutors and defense lawyers and, ironically, the rights of criminal defendants. The majority's order applies to none of them. So she criticizes and bashes this seemingly inexhaustible superintending authority over courts and the judicial system of this state to indefinitely suspend the law enacted by the people's representatives in the legislature. Last week, the majority trampled fundamental rights under the Sixth Amendment to the U.S. Constitution. This week, the majority ignores governing statutory law and instead invokes its ever-evolving, quote, superintending authority to substitute the majority's preference for that of the legislature. Specifically, the majority suspends the right to a trial by jury in all civil proceedings, indefinitely keeping children from their parents and indefinitely depriving the mentally ill of their liberty, among other infringements of substantive individual rights. That's some of the things you might not be thinking of, just because you're not a lawyer or legal professional, or maybe because you haven't been through this. But it's not just important that criminal trials aren't suspended. I alluded to this earlier, but Chip's cases, keeping children from their parents, depriving mentally ill of their liberty, among other infringements of substantive individual rights. In doing so, the majority invades the province of the legislature, and violates the separation of powers and creates a confrontation of constitutional magnitude between the legislature of this court. So she dissents. So I think I'm going to leave it off there for the most part. There's a lot more great language here, and I'd love to read all of it for you, but I already suspect that I've stepped over my bounds a little bit here. This might not be the most entertaining read for someone who isn't a lawyer or a legal scholar or something like that, but the reason why I went through and I read a lot of it anyways is because this needs to be read, and people need to be reading this. And I think that it's a very brave thing what Justice Rebecca Bradley is doing by speaking up about this and probably irritating people to no end with, her cry for liberty. However, I don't want to frame her as like some libertarian hero either, because there's certainly things that she has. I couldn't name it off the top of my head, but I'm sure that there's things she's done to limit liberty in negative ways. But I'm sorry. It's a bit late here. So I would urge you all to read the language, read her dissents, read the orders that they're putting forward, and go to your own Supreme Courts in your own states and try to find out what's happening with COVID-19 and see if there's any dissent. Sometimes there's people out there fighting, and sometimes you have to give them, I think, the respect that they've earned and deserved. And in this point, I think that more people should be hearing the dissents that Justice Bradley is putting out. And so here, as a member of the Wisconsin Bar, I'm trying to give light to the work that she's done and the dissents that she's made. And she's fighting. She's fighting for... Maybe she's not the purity, not the pure everything needs to resume right now. However, she's out there, And so I think I'll, for the most part, leave it at that. Everything is upside down world right now, and we might very well be at the point where the largest affronts to our constitutionally guaranteed rights, and moreover, it's not the rights that... it's not because the Constitution exists as to why you have these rights. You have these rights because you own yourself and you own your body. And you have, through that, you have rights. It's property rights and things that we've talked about on this show quite a bit. So I'll leave it there. I want the content kind of to stand for itself, but I hope you enjoyed it. I hope I didn't make a mistake by reading a legal opinion mostly word for word. But check me out, libertyweekly.net. If you're looking at the screen, the video version, you can see the website. If you want to support the show, click on that Patreon button right there. I've been releasing Patreon content since I've come back, planning to do some extra episodes. Check out the Liberty Bigly podcast. This is my B-side podcast that I have on anchor.fm. You can find it on all your regular podcast podcatchers. Oops. And this is where I do off-the-cuff B-side recordings. And it's akin to bonus content. It really is. That's Liberty Bigly, as in Donald Trump said, we're going to win bigly. So Bigly. It's at anchor.fm/Liberty Bigly. Liberty and then Bigly. I'll put a link in the show notes page at libertyweekly.net / I think this is 135. I'm sorry. 133. libertyweekly.net / 133. And the Liberty Bigly podcast, if you look on the screen, you can see I put out 3 or 4 episodes in the last week. So that if you enjoy what I do, these are shorter episodes. But if you enjoy what I do, check it out. I can record things right on my phone with the Liberty Bigly app. Or, wow, the Anchor.fm app. And you can see there's a community. You can see there's a community of listeners. They are the libertarian elite. Excuse me, they're the Liberty Weekly elite, are the people who are listening to the Liberty Bigly podcast. They're like the super fans. They listen to the deep tracks, man. So anyways, I'll quit while I'm ahead. So I hope you enjoyed this episode. I'm looking to come back with another episode next week, hopefully with Keith Knight, where we're going to be talking about things that are a little bit off the rails in terms of things we haven't talked about before. But I think you'll enjoy it. It's kind of in a Harry Brown, how to find freedom in an unfree world kind of way. And I'm sure we're going to find a great way to spin it to a Liberty audience. So again, check me out. Patreon, patreon.com / Liberty Weekly. There's a PayPal button at libertyweekly.net if you want to support the show. Subscribe, rate, review. I could really use some reviews on iTunes if you'd like to do that. libertyweekly.net / iTunes. And yeah, anyways, Liberty Bigly too. Check that out. So thanks for bearing with me. I hope you're having a great weekend, and we'll